Well, good morning, everybody, and welcome to our Exchange webinar series. Thank you for joining us for today's focused discussion on paid family and medical leave compliance and related workforce compliance. Very timely and important topics for employers across Maine. This morning, we'll be covering what businesses need to know about Maine's PFML law, implementation considerations, employer best practices, as well as the state's pay transparency requirements. We will leave some time at the end of for a live Q&A session. I'm Nate Cloutier. I'm the Director of Government Affairs for Hospitality Maine. I also do work with and for the Maine Tourism Association. We're pleased to partner on today's webinar alongside the Retail Association of Maine and the Maine Grocers and Food Producers Association. I'm going to hand things over to my friend and colleague, Curtis Picard.
Thank you, Nate. Good morning, everyone. I'm Curtis Picard, President and CEO of the Retail Association of Maine. We're glad to have you with us today for what we know is an increasingly important conversation for Maine employers. As workplace policies and compliance requirements continue to evolve, our goal is to provide practical information and timely updates that help businesses prepare and navigate these changes with confidence. We are also pleased to welcome members of the Maine Pharmacy Association, the Maine Society of Health System Pharmacists, and the Maine Cheese Guild, organizations that we work closely with. We want to make sure employers of all industries get solid, actionable information. At this time, I'd like to invite Christine Cummings to briefly introduce herself on behalf of the Maine Grocers and Food Producers Association.
Good morning. Thanks, Curtis. Thanks, Nate. My name is Christine Cummings. I'm the Executive Director of the Maine Grocers and Food Producers Association. Pleased to have you all with us this morning and taking time out of your busy schedules. We'd like to take a moment to recognize today's webinar sponsors, those who continue to support the work of our associations and make these webinars possible. A sincere thank you to Poland Spring, Shaw Supermarkets, Associated Grocers of New England, Altria, Bizzuto's, CNS Wholesale Grocers, Coca-Cola Beverages Northeast, Hannaford Supermarkets, HP Hood, and Pepsi. We truly appreciate their continued support. A few procedural notes before we get started. All attendees are muted and you all will remain muted throughout the webinar. We will hold a question and answer session at the conclusion of the presentation. To ask a question at any point, simply move your cursor to the bottom of the screen and click the Q&A icon. If you don't see it, you may find it under the three dots on the right-hand side of your toolbar. Type in your question and click send. This webinar is being recorded and will be available afterwards for those who would like to revisit the discussion. And with that, hand it back over to Nate.
Thanks, Christine. This morning, we're very excited and pleased to welcome our presenter, Tawny Alvarez, a leading labor and employment attorney with Verrill. Tawny advises employers on a wide range of workplace and compliance matters. She regularly works with businesses on employment law issues, including paid family medical leave compliance, workforce policies, employee relations, and labor regulations. Tawny is well known in the industry and the legal field for providing practical, business-focused guidance that helps employers navigate through complex and ever-changing workplace requirements with confidence. With that, Tawny, we're very excited. Thank you for being here this morning. The floor is yours.
Thanks, Nate, and thanks, Christine and Curtis. Thanks for everyone for being here and attending today. I'm sure many of you are aware Maine paid family medical leave went into effect on May 1st of 2026 with benefits being paid out at that period of time. Today's presentation is not going to focus in on the basics, however, in any regard. So we're presuming that you have a basic understanding of things. Even though I'm making that presumption, we'll go to our first slide. With that presumption, I'm just going to level set for everyone, right? So it's a state-run insurance program, even though we don't use that language, that provides partial wage replacement for employees who need to take leave for a number of covered reasons, including leave because of their own serious health condition, to bond with a new child, to care for a family member, for certain military-related exigencies and caregiving, and for safe leave related to domestic violence, sexual assault, or stalking. It provides up to 12 weeks of paid leave in most situations, and it applies to every single employer in the state of Maine. I continuously am hearing some people say, well, I didn't know it applied to me. If you have a workforce in the state of Maine, if you operate in the state of Maine, it applies to you. The way that it's funded is that there's 1% of wages that is paid into a state system or the Paid Family Medical Leave Commission, and it's split 50-50 between employers and employees. However, if you're an employer with 15 or fewer employees, you're not required to pay your 0.5% of the tax. It's important to keep that 15 employee number in mind, especially for many of our smaller employers. That number is based off of established payroll for 20 or more calendar work weeks in a 12-month period that ends on September 30th of each year. I say this specifically to those of you who may be joining us from the Hospitality Maine team that may have a workforce that's seasonal in nature, that fluctuates, terminating employees at the end of a season so that you don't have 70 employees at the end of the year, except that you really only have 10 who work consistently. Being mindful of how employees are counted is really important, both for this statute as well as for the pay transparency statute that we're going to touch on just briefly towards the end of today's presentation. So that's our level set as to what we're here to talk about today. Big picture, it applies to everyone. All of your employees are likely entitled to leave in some regard. They may not be entitled to any benefits, but they would be entitled to make an application and seek payment. So next slide. We are 42 days into this. We're 42 days into this program, and some of the official data that we have, right? 6,351 applications have been submitted. Of those, 40% remain pending. 33% have been approved, 11% are erroneous applications, and the remaining 16% of applications have either been denied or canceled by the claimant. Of the claims that have been submitted, 39% are concerning an applicant's own medical condition, and 30% of claims are for bonding with a new child. So that's the two top reasons that we're seeing leave taken. I don't think that's surprising for many of us who were experiencing issues with leave or attendance more generally, or saw the reasons why our employees were taking leave even prior to the implementation of this program. In our first month of data from May 2026, the fund has paid out $2.8 million. Now, this may not seem like a lot, it may seem like a ton, but we have to level set. Actuarial data that was developed in December of 2025 estimated that in the first year of the program, right between May and December of 2026, we would pay out 18 million out of the fund, and of that, 8.8 million would be claims administration, and the other 9.5 would be other administrative expenses. We're 2.8 in the first month, and they estimated that we'd only pay out 8.8 million in this first year. So I have a feeling we're going to be over what the claims administrators had estimated for this program more generally. What does that mean for each of you? Unfortunately, under the statute, it is not capped at 1% of employees' income. So I think it's likely that we're going to see an increase in the amount of wages that are going to have to be paid into this program by employees and employers. And that may lead or shift the burden that may cause employers to shift and go to a private plan. And we're going to talk more about private plans later in the presentation. So that's the official data. But what about the unofficial data, you ask? Let's jump to that next slide. Unofficial data, and I've gotten it from super reputable sources, all right? Social media and client calls. So I've gotten it from a multitude of different social media sites and different kind of harpings, I'd say, on the internet. And some of the things that we're seeing that are being posted or that I'm hearing from clients directly are some things that were expected and other things that were unexpected. The expected issues were delays in receipt of payment, that individuals have made application weeks ago and either have not started to receive funds even though they have been approved, or in some cases the applications remain pending. Now, in those situations where the application remains pending, I would presume that there's a failing to provide the information that has been requested either on the part of the employee, a healthcare provider, or the employer, but that's not clear because this is not scientific data. So this is, however, going to create extreme stresses for our employees as to their finances. And that extreme stress for our employees is going to create larger issues related to short-term loans or the use of PTO. And we're going to talk about ways to deal with that later in the presentation. But understand, like right now, unofficial data, we already know this is a problem. We're also seeing frustrations related to employment changes between employers using the public plan through the state and AFLEC, and those who are using private funded programs through Unum or another service provider. And the reason for that is because the definition of wages in our private plans is different than the definition of wages that's provided under the statute. Under the statute, wages is defined as all money that was earned within the state when you pay in that 1% into the state pool, when that is taken out of each employee's paycheck each week or biweekly or however often you pay. Under most of the private plans, however, there is a slight modification in the definition of wages that creates much larger ramifications for employees more generally. And that's that the definition of wages indicates that it's only money paid by the employer who has the plan to the employee. What does that mean, right? Well, when we determine how benefits are paid out, whether it's a private plan or using the state's plan, it is parallel. It has to be parallel under the statute. And that means that the employer or the state are going to look back at the period of the first 4 of the last 5 quarters of the employee's work history. Under the state program, right, if an employee jumps between one employer who uses a state program and another employer who uses a state program, it's going to be really easy to look back and see the first 4 of the last 5 work quarters. If, however, an employee works for an employer who's using the state program and they've worked there for the last 1.5 years and have been paying in for that whole period of time, right? And then let's say in February they moved to a new employer and that new employer had a private plan. The wages that were paid into the state program aren't going to play a role in determining eligibility for benefits under that new private plan. And in most cases, an employee is being denied because they do not have any wages from the first 4 quarters of the last 5 quarters for determining what benefits are. So this is really important that we help employees understand, especially our new employees who may be looking at leave, that the money that they paid into the public program, into the state through AFLEC, is not going to play a role with our employers who have private plans. Now, I'm just going to reemphasize this is only if you are an employer who has indicated who has an approved private plan that's been approved by the state. So that's one of the big issues that we're seeing. We knew we were going to see that in starting around March, where we were able to start seeing the language in many of these private plans. And now it's playing out with people being really upset and or having counted on receiving some form of wages during this period and finding out that they won't be receiving any. One of the unexpected things that we're seeing 42 days in is the quantity of employees who are unclear if their employer is using the public or the private plan. So instead, people are just hopping online and presuming that their employer is using the public plan, going through the whole application, being denied because come to find out, the employer actually has their own private plan and therefore have just done an application to the wrong entity. Um, let's jump to the next slide and talk a little bit about how PFMLA interacts with other paid leaves. And when I say other paid leaves, I'm talking about things such as PTO, earned paid leave, short-term disability, or whatever you may call paid leave within your organization. Vacation, universal time, anything along those lines. We can jump to that next slide. So it's important to understand the effect that other benefits have on PFML benefits. And there's a handful of them that will not reduce an employee's benefits under the paid family medical leave. And that's benefits from an employer's short-term disability insurance plan, any top-off payment that an employer voluntarily chooses to provide to employees so that they get to 100% of their regular pay. Because as a reminder, the paid family medical leave only in most cases is going to fund a portion, and there's still going to be, 40 or more percent of the employee's wages that are uncovered by the program. There's also the ability for employers who don't have maybe a PTO top-up plan or who maybe use unlimited PTO, that they would simply allow the employer to top up without the use of PTO so that 100% of pay is being provided. I see this happen a lot in situations where employers have a program of some format, most often related to parental leave, where they will provide a number of weeks or in some cases months of full pay for parental leave that is outside of a PTO policy, right? In those situations, those wages from the parental leave policy could top up to 100%. And later in the program, we're going to talk a little bit about many of the things that you need to keep in mind in order to make sure that there is not disagreement between your policy and how PFML is being paid out. Additionally, recall that workers' compensation benefits for partial incapacity for an injury that occurred prior to the PFML claim also does not decrease PFML benefits that are applicable to the employee. Let's jump to the next slide and discuss how PTO's interaction and that benefit plays a role. This is actually where I'm speaking to employers the most, a couple of times a week in most situations. And it's how to get the current either accrual or program itself to comply and interact appropriately with PFML, right? So we know that it's available to help employees top up or create it so that they have full payment during their leave. However, we cannot require that. So for our employers out there who previously had extremely generous leave policies, let's say that you allowed employees to take 8 or 12 weeks of leave in the course of a year. And in large part, you were doing that to help employees who maybe did have the need because of a health condition or child illnesses or things along those lines, right? Or more generously, like if people didn't have any of those health conditions, could use it for a vacation or their own personal leisure. Because you cannot force an employee to top off their leave. If you currently have a generous PTO policy that provides, let's say, 12 weeks of leave or 8 weeks of leave, right? That is in addition to what they're getting under PFML. So they could take, I'm only going to take 60% of my pay for this 12 weeks of leave that I'm out under the PFML. And then I'm going to take my other 12 weeks of leave that my employer provides under PTO or whatever, you call the policy, resulting in the employee being out of work for 24 months and doing it all within the current provisions of your policies and practices. Some of the reasons why employees may be choosing, or we would push them to use some form of PTO in order to top off their leave. It helps with making payroll deductions for things such as health insurance premiums, dental premiums, anything that is currently a deduction from the employee's paycheck. You need to understand that while they're using the PFML program, if they're not if they're not topping off with PTO, you don't have any money that you are able to recoup the costs of, if they have a short-term disability policy that they pay into, if any of the other benefits that you offer to the employee. So it's important before someone goes out on leave that you have a conversation with them and help them understand if they choose not to top off, they are going to have to be writing the company a check every week. Now, you could have it so that they have to pay back the money when they return to work. However, you'd have to have a written agreement with the employee concerning that. And oftentimes it's going to be harder to recoup if the employee ultimately doesn't return to work after the leave. When I say harder to recoup, I literally mean hire an attorney and do a breach of contract claim in court. I have some of those cases. I hate those cases because people pay me more money than they're ultimately going to get from the employee. So I highly, highly recommend to employers all the time enter into an agreement where they're paying in real time or they're prepaying for those benefits, because recouping the cost later is just, you're honestly chasing nickels with quarters, and it's just not a good use of corporate money. So you can't force that use, and it's important to understand that while you can simply pay the employee, and in that situation you can still continue to take the benefit amount out. Remember earlier, probably 3 or 4 slides ago, where I said, hey, remember there's this delay in receipt of funds? So for our employees who are taking PFML for their own serious health condition, there's a couple of things to keep at top of mind. The first thing is that there's a 7-day waiting period between when they make their application and when they're going to be eligible for benefits. It's important that your PTO policy notes that if they're not getting PFML benefits, that they need to use available PTO. Now, you can't force them to use all available PTO, but I would have the policy set up that they need to use all available PTO except for, and I would do 8 hours or some other increment of time that you leave available, so that you don't have them taking 7 days of unpaid leave while they still have this bank of PTO that they're going to use later. So while you can't require top off, you can require them to use it for the first 7 days if the leave is for their own serious health condition. You can't, however, require that if they're caring for someone else, because there is no 7-day wait period in that situation. So let's say you have a situation where an employee's made an application as a result of their own serious health condition. They've gone the 7 days and they've used PTO, but now they're still not getting funds. They've been approved, but financially they haven't started getting the money. They come to you and they say, okay, I want to use the top off, but the top off only results in them getting 40% of their pay or whatever kind of that top off amount is going to be, and it won't be their whole pay. In those situations, for our employees who are living paycheck to paycheck, that might be insufficient. The inability to have access to all of their wages may be such that they're unable to make rent or they do other things, and they say, no, can you just pay out all? Like, I still haven't gotten paid. Can you do 8 hours for each of these days? The answer is no, unfortunately. I mean, if you do that, you're going to create massive tax implications for yourself, because even though there's a delay, the individual is still going to get the money at some period of time. That means for the weeks in which you've paid full PTO to them, they've made in excess of what they should have, which violates the statutory rules and can result in penalties for you for that overpayment. So the easiest solution I can come up with, and I don't like it at all, is that you have to do some type of contractual arrangement using some type of like rainy day fund where you provide employees with a loan of a certain amount with the understanding that within X, Y, and Z period of time, they pay back that loan. Why don't you like that, Tawny? I don't like that because it's again one of those contracts that if they don't pay it back, you have to go after them in court. Now, you can have it so that it's set up to deduct from their wages once they return to work. If they don't return from work to work, however, then you have a larger problem. So that's one of the issues with the current delay in people getting their money and the way in which PTO can be used to supplement but not um, overlap with that leave. Let's go to the next slide. So, what does reduce PFML benefits? And this is important because I think some people are, are misunderstanding that a little. Unemployment, workers' compensation, um, under federal temporary or permanent disability, but the big one is a permanent disability policy or long-term disability policy. So depending on when your long-term disability policy goes in effect, while most of the ones I see go into effect after 16 weeks or after 12 weeks, if yours goes into effect earlier than that, it's important that you understand that any money employees are receiving, will directly impact their availability or the ability to obtain funds under the state program. Let's jump to the next one to discuss how we coordinate the current leave with other state and federal leave more generally. For most employers, let's jump to the next slide. Any employer who has 15 or more employees, this is relevant to, because if you have 15 or more employees, you are covered under Maine's unpaid FMLA statute, which provides up to 10 weeks of unpaid leave in every 2-year period. And for our employers who have 50 or more employees within a 75-mile location, those individuals are covered under the federal FMLA, which provides for up to 12 weeks of leave within a 12-month period, as long as the employee's been employed for over a year and worked over 1,250 hours. So, under the statute and when Maine PFML was created, everyone, all the legislators, and just in general, everyone who is really focusing on this said, hey, don't worry. People aren't going to be able to stack all this leave together because they work harmoniously together. So employers don't have to worry because employees are going to take the leave all at the same time. That's partially accurate, but it's not completely accurate. So, where we're seeing difficulties arise is time usage. So, under federal law, you cannot require an employee to take more leave than they need. So if Tawny has a serious health condition that she needs intermittent leave for because she has doctor's appointments every couple of weeks or maybe even weekly, and then sometimes I'll have a symptom flare, right? If I need an hour to go to the doctor, that's FMLA qualifying. But under Maine FMLA leave, unless the employer and the employee, unless the employer agrees, right? The smallest increment of time that can be taken is 1 workday. Now, you as an employer can choose to allow it to be a smaller increment, but for a lot of you, I understand that, the day starts at a certain time, you have shifts that need to be covered. If the person isn't there for a period of time, you need to bring someone in to cover the shift, and therefore it's difficult, or you have to overstaff in order to accommodate even a 1-hour appointment. In that situation, however, when Tawny leaves and goes to her doctor's appointment, she's used 1 hour of federal FMLA time, but I could choose to not take any federal FMLA time, choose not to take any state PFML time and not put it in through the program. So even though I've used an hour of leave, I'm not using it through the PFML program, so I'm not getting paid for it there, but I could ask for PTO from you all, but it just takes me out of work for more time than was expected more generally, because I'm still going to be able to use that full day later, next week, tomorrow, whenever I choose, right? So this difference in the amount of time that can be used can create problems if you're an employer who says that PFML can only be taken in one day or 4 hour increments or any increment, right, that is larger than 1 hour. The other place that we're seeing significant issues is employees who are out and choose not to take PFML, but to just take FMLA. And you might be saying to yourself, well, why is that? Why is that problematic, Tawny? And where this comes into effect is for those employers who, up to the date of the starting of this program, have been compassionate and generous and empathetic and have provided employees with leave, but have not filled out paperwork to show that this is FMLA leave more generally. So let's jump to the next slide. So, as it relates to the FMLA and the timeline interchange, employers can require employees to use PFML leave when they're on a federal FMLA leave, except when the leave periods differ. So, under federal law, the regulations provide that if an employee does not choose to substitute accrued paid leave, the employer may require the employee to substitute accrued paid leave for unpaid FMLA, but it has to be in that smallest increment of time, right? So Tawny takes 1 day, 1 hour away from work. She doesn't apply for FMLA. The employer can require her to use PTO there. However, understanding that you run into like one of two issues, right? Let's say Tawny only needs 1 hour away from work, but it is for a PFMLA issue, and she chooses to make her application for PFML, but then she comes back to work after an appointment. So she works for 7 hours. She puts in for PFML time, seeking a whole hour. Saying that she took this hour of leave and seeking a whole day of pay, right? There's going to be this problem between how PFML authority is able to account for that time away from work, because they're not going to be able to pay the employee for the whole day, which means that the employer is going to have to pay 1 hour of PTO plus the 7 hours that were worked. And this is logistically, both from how we are documenting it as well as how the pay is being processed, is creating, a host of issues for employers. The regulation itself establishes that you can only require employees, the FMLA regulations, not the PFML, says that you can only require employees to use the smallest increment of time that's necessary to cover the FMLA leave. And that's where it's creating issues as to how it interacts with the paid FMLA statute. It's important to understand that Maine construes the Maine unpaid FMLA system the same as the federal rules. So when I've talked about like, hey, if federal law requires this, if you're an employer who has between 15 and 50 employees, this is also applicable to you, because the same rules are applicable under Maine state unpaid FMLA. And their interactions with paid FMLA is going to be the same. I am just going to remind people that if you do have questions about anything that I'm saying, please use the Q&A function, and we are going to jump to that at the end. But if I'm not seeing Q&As in there, I told Christine and Nate and Curtis before we started, I can talk all day long. So if there's not Q&A in there, I'm going to keep talking. But if there are, then I do want to be able to answer everyone's question. So let's jump to the next slide here. Okay, so some absences as well, it's important to understand that while they may be covered under the PFML, they're not going to be covered under FML. So that means that if an individual is taking PFML to care for a grandparent or care for a grandchild or to care for a covered individual, remember that kind of much larger and broader statute, or for a stalking incident or something along those lines, right? Those aren't covered under federal FMLA, which means that if I take 4 weeks of leave to deal with an issue with my grandparent, right? I still have 12 weeks of of unpaid federal or state FMLA, excuse me, federal FMLA that I can take at a later date, resulting in me being out of work for 16 weeks, more than the 12 weeks that is encompassed kind of within the PFML. And there can't be any adverse action taken against me or retaliation because all of that would be protected leave. Employees cannot choose to take one leave and save the other, but remember the employer restrictions as to time, and then these differences in definition can result in the employee getting up to 24 weeks of protected leave more generally in the course of whether it's a calendar year or whatever year basis that employer is using to judge time. So the other place that we're seeing issues, and this will only be an issue we experience for the next year, are employers who had employees who had some fairly serious attendance issues prior to the beginning of PFML. And most of these are situations that I'm only just now learning about because an employer chose to provide leave or time away from work for an employee with a serious health condition as a reasonable accommodation, as they're required to do. In those situations, if the employee was not entitled to FMLA, maybe because they hadn't worked the requisite hours, maybe because they had been employed for the employer for less than a year, the problem is that time away from work, since it wasn't FMLA qualifying, does not reduce any of the time away for PFML. So let's say you have an employee who suffers from migraines and they were missing, 1 day a week for the last 6 months. And it was a reasonable accommodation you were providing. It wasn't an undue burden. None of that time. So those 24 days of leave that they've already taken is not going to decrease their eligibility for PFML. They're now going to get PFML for that condition and have that additional time. And that's definitely causing stress for some employers who are like, well, wait a second, shouldn't it be reduced? And the answer is no, because it wasn't FMLA qualifying. I also have some situations where the individual would have been entitled or eligible for FMLA, but pushed the employer off and failed to complete documentation, saying, no, I don't want to use FMLA. It's not that bad. And instead of the employer saying, well, I know that it's FMLA qualifying, so I'm going to complete the documentation and we're going to treat it as such, even though you don't want to, which is the standard under the federal statute. They didn't complete that paperwork and now they have an application for PFML and they can't evidence the previous time taken because they don't have documentation evidencing that FMLA had previously been taken by the employer. And so that is creating, or resulting in the employee being entitled to additional leave. Next slide. The other question I'm getting a ton of is my employee has applied for PFML, but I have absolutely no data or understanding about anything that's going on other than data from the PFML authority saying that it's been approved. Is there anything I can do? The answer is yes, right? if you're still going to follow your normal process for confirming and designating state or federal unpaid leave. And it's not you can, it's you have to. If you fail to do so, you've violated the FMLA, and you could get a claim at some later period of time that you've interfered with their federal FMLA rights. Now, as a defense, you would say, well, no, because they still got the time, but there are notice requirements under the federal FMLA. So it's really important that you continue to follow your normal process. Additionally, for our employers who are our employees who are seeking some form of intermittent or reduced schedule leave that could be an accommodation under the Americans with Disabilities Act or the Maine Human Rights Act, you can also do accommodation forms to get a better understanding of kind of what limitations the person has as to the condition. One of the things I am seeing that's causing frustration for a lot of employers is employees who have a health condition that doesn't fully limit their ability to work, but could be accommodated with some change in the job duties or functions that are non-essential. So, the definition of a reasonable accommodation. But instead of attempting to make those accommodations, the person is simply taking PFML leave. It's frustrating for the employer, but it is permissible under the rules. So as an example, Tawny has a serious health condition where she's fractured her ankle and she can't walk for X, Y, and Z period of time. Well, interestingly enough, for me to perform my job, very little walking is necessary. I pretty much sit all day long. I know some of you probably have similar jobs. So I could still arguably do my job. I, however, can apply to PFML and I'll be approved for it and then be able to take however long I need to recuperate. It's frustrating because the employer's like, wait, but they could be working. Yes, and that's the disconnect between the Americans with Disabilities Act and any of the FMLA leaves, which try to take an employee out. So in those situations, though, where I say, hey, we can learn more information, give them the unpaid FMLA paperwork and ask them to complete it. Great. Now we get more information about why they're out, helps us to better understand things. However, if the employee fails to complete the paperwork, right, and we're still waiting for a ruling from the PFML authority, this is where, see how it says it depends, that horrible answer that you get from attorneys all the time. If it's still pending with the PFML, then you're kind of between a rock and a hard place. If PFML has already been granted, right, but you're unclear as to the why, is it for a grandparent? Is it to care for a grandparent? Is it to care for a child? Like, if you have absolutely no data about the reason for leave, this is going to create issues as to whether or not you can designate the time away as FMLA qualifying under federal law. And those are situations where I do highly recommend that you consult with labor counsel in order to figure out how to remain in compliance with both of those standards. Let's jump to the next and talk about how it's going to interact with other employer policies and practices. Next slide. So first, the benefits, and we touched on this very briefly, but remember that taking PFML does not affect an employee's right to accrue or receive other employee benefits. That means accrue vacation and sick time, continue earning bonuses, advancements, seniority, service credit, maintain participation in benefit plans and programs. What everyone seems like they rationally understand is, yep, they don't lose health insurance, fine, no problem. Where I'm seeing a ton of issues is that if your system, whoever sets up your payroll system, that it's set up that you only earn PTO for actual hours worked, right? That would not be in compliance with the PFML, and you're going to have to go in and you're going to have to change the system so that every hour of PFML that is taken by the employee is treated the same way as actual hours worked. So employees will earn vacation, PTO, sick time, whatever the accrual thing is, for hours in which they're taking PFML. So not working, but still accruing PTO, vacation, whatever it is. I'm finding more and more employers who have not checked in with their payroll provider or have not checked in with their accounting department to make sure that that change has been instituted. and that leave is being provided based off of PFML time away. Next slide. Benefit coordination, right? We talked about the health insurance coverage and how the premiums are going to be covered, making sure that the employee understands that it's their responsibility and having some type of calendar or schedule set up to make sure that we don't get far behind on collecting the premiums is really important. Now, this also has larger benefit elements concerning coverage under the same conditions, but what if the employee ceases paying? In those situations, if you have an agreement that they're going to pay and they cease doing so, you could end benefits, understanding that there could be COBRA rights and all those other elements. But again, honestly, what's going to happen there is it's going to create more paperwork. The employee is then going to pay. Then you're going to have to re-add them back to the policy. It's just more of more administrative task, and making sure that you're clear with whoever is in your payroll or accounting system as to how you want to handle that is really, really important. Next slide. Job protections, understanding that if the employee has been employed for at least 120 consecutive days, they have to be returned to their owner equivalent position. But if they've been employed for less than that, that they're not entitled to job protections during the leave. At the same time, however, remember that there is the anti-retaliation provision. So while they don't receive the same job protections, understanding that you can't just terminate them is really important. One of the ways, especially for any of you who have more seasonal businesses, is terminate everyone at the end of the year so that you restart this 120 consecutive days for employees more generally. If you have a private plan as well, understanding what I talked about on slide 2 about remember, it's based off of when they were your employee and getting your pay, right? So terminating them and then re-adding them means that the last 4 of the 5 periods, right? It's going to change entitlement. And if they're unable to get paid, they're less likely to take the leave is kind of what all the data shows. So keep that in mind. Next slide. Where we're seeing a ton of issues right now with the job protection element is the reasonable notice. We have more and more employees who just aren't showing up for work. And on the 3rd day, when we're reaching out and saying, haven't heard anything, they snappily send back, I've applied for PFML. Usually they've done it 15 minutes before. At that period of time, we have these 3 days that are unpaid, and we're in this unfortunate gray area where we're like, okay, well, here's FMLA paperwork. Help us understand why you're not coming to work. And we're then waiting to see if PFML is going to be granted before we terminate someone. And they're just giving us breadcrumbs. I don't feel good, or I have bad knees. And you're like, well, what do your bad knees have to do with your inability to do this job? And that's where that interchange between the disability standard and PFML is coming in. And one more, I think one more. No, that's okay. We'll go to the next slide, but we're pausing here, right? Because these are extra slides that we have in place, but we have some questions. So I'm going to turn it over to Nate for those questions so that we can get those questions answered in the next 10 minutes. And then if we don't have any more questions, we'll jump back into these other elements.
Sure. Thanks, Tawny. Great job. It's always a lot, and I'm still learning a lot about this, even as you're explaining this. So I really appreciate it. A question that came through: how can an employee earn a bonus if they're not working to earn it? For example, if the staff receive a bonus for supporting a special event, the employee who was not there to help also would get paid a bonus?
Yep. We presume that they were there to help and they were doing all the things that they needed to, and thus get the bonus. And that goes to it goes to this fairness element that, doesn't underlie the statute and is more difficult for employees and coworkers to understand. But yes, they would still get the bonus.
Another question that came through, earning Maine earned paid leave is based on 40 hours of work. So would they still have to accrue EPL as well?
Gosh, these are great questions. Yeah, even though the statute says that it's for time actually worked, right? The PFML statute treats the PFML time away as time actually worked. So the employee would earn paid leave for time in which they are on paid FMLA.
Gotcha. I can give you a question that's come through to me quite a bit. Um, what should employers be doing for documentation purposes, especially around undue hardship? Is there specific things in the law or rules that people should be documenting, just as a covering your own uh, liability type of situation, or what should employers be doing?
A reminder that undue hardship is only going to be applicable for a very small handful of situations, right? Tawny is pregnant and she's going to give birth. You can't change the timeline of when Tawny's going to give birth. So don't even make an undue hardship argument there, right? Undue hardship is really only going to be worth your time and effort when Tawny, has scheduled medical appointments that she can choose when to do it, and she chooses to have it every Monday morning for 4 hours, and that's the same time that she's supposed to be doing payroll, right? So taking into account that the undue hardship argument does not mean that the person can't take leave, it's just a change in when they can take leave. And in any exigency situation, I'm not going to be able to change it. Like I broke my ankle or whatever I did, that's my own health condition. Unlikely. It's really going to be more for those scheduled things. If you are seeking the undue burden, the statute itself does list the things that are going to be taken into account. And I highly recommend that you go onto the portal, that you look at those elements and you keep it very directly as to these are the things that they're asking for and the elements that are considered, and use those as your talking points. So go on, use that resource, understand that it's only to reschedule the time, or Tani needs to have a surgery that's elective. She can choose to do it, starting on July 1st because she wants to take the summer off, or she can choose to do it in August, right? Those type of things, there's very few times in which it's going to be applicable, but using the resources on the PFML page is really important for that.
Good reminder. Closing the loop on earned paid leave was a follow-up question. So for the earned paid leave, we would base it off how many hours per week they're requesting.
Based off of how much, yes. So if they're paid for one day and one day is 8 hours, then they would get 8 hours. It would be as though they work those 8 hours.
This is a question that comes through quite a bit with paid family medical leave and uh, other labor laws. What do you recommend employers do if they're looking for specific language to include in their employee handbooks?
And I have that horrible attorney answer that it depends on it depends in part on your other policies and how you want to treat it. Now, the best way to go about it and how I've seen some employers do it is go to the statute itself and say, go to the retaliation provision. You won't be retaliated against for taking PFML. And then go to the definition section and say, you're entitled to take PFML for these reasons in order to apply. And then they put the link. The big place that you need to be really mindful is about your notice provision as to, hey, you have to let the employer know at least 2 hours before your scheduled shift that you're not going to be there, to make sure that they are still complying with those policies and that it interacts. And then the other element is if you are covered under unpaid state FMLA or unpaid federal FMLA, that you're very clear that they run at the same time so that employees don't think that they can stack. Because I have gotten some of those arguments, like very explosive emails from employees who don't understand and thought they could stack them.
We had
Yes.
another question come through. There's an employee that has multiple disciplinary actions against them. They think they're about to be fired, and then they decide before they're going to be let go that they could take paid family medical leave still have to have legitimate reasons to be able to use that leave, correct?
Yes, but here's how our really smart employees are doing it, right? They're making the application and giving themselves that time while the application is pending to try to find another job so that they're not being fired and while the application's pending. Now, those applications that don't have legitimate reasons are going to take longer, right, to be completed more generally, whether or not there's delays in getting a doctor's note or there's an appeal or anything along those lines. So they are using that either to extend their time with the employer or kind of to just make it more difficult for the employer more generally.
What should employers know about communicating with employees while they're out on leave?
It should be limited and all should be going to their personal email account, or you should get permission to use their personal cell phone or text. I've seen some that continue to communicate on their work email and then get mad that the employee is not responding, and I have to remind them they're not working, so they're not looking at that. So making sure you have that data. It should be very limited. I usually suggest that there is a check if it's an extended period, if it's 12 weeks, that there's maybe a check-in at 6 weeks just to say hope all is well, and your recovery's on track. And then when you get closer to either 2 weeks before the leave's supposed to end or a month before, giving the employee some sense of what things will look like when they return. We have your return to work date as X, Y, and Z. Please confirm that. This is, that's helpful for the employee because they're likely going to start feeling a little bit of anxiety about the return and making sure that they have all the data points that they need. The check-in kind of midway through is kind of more of an empathetic, like, hey, we hope you're well. Limiting what you're asking the employee for, though, in that period is really important. There shouldn't be any requests for work to be done or data sets or anything along those lines.
Tawny, if I can jump in, I know
Yeah.
we're getting close to 9:30 as well, but we did have some folks that had interest in learning about the pay transparency law that's going to be taking
Yes.
effect soon. So
Yes.
we are recording this webinar. So if folks do need to drop off at 9:30, please know we are going to be sharing this recording with everybody who registered. So we can certainly get back to more paid family leave, but if you can touch base on that, that would be helpful.
Absolutely. Yes. So, pay transparency law is passed and will go into effect later this year. And it is applicable to any employer who has 10 or more employees. So remember earlier in the presentation where I was talking about keeping your employee headcount down is important, not just for PFML and the amount of taxes that you pay towards that, but also as it applies to earned paid leave and pay transparency postings. So an employer who has 10 or more employees has to make sure that any postings that they have for jobs includes a statement that lists the prospective range of pay that will be offered to a successful applicant. Now, what is range of pay? I've heard people say, well, can I just do minimum wage to $1 million? No, unfortunately. That happened in Colorado for an extended period of time. And of course, Maine isn't going to make the same mistake that was made over there. So range of pay is any applicable pay scale that you have for that role, any previously determined range of wages for the position, the actual range of wages for those who currently hold the position, or the budgeted amount for the position. So range of pay does have breadth in how we determine it, but it's really important to understand that kind of before this goes into effect, you're going to have to make sure that you look at each job and um, figure out, hey, what is the range of people who have this job title? What are they making? What is it based off of? And the reason for this is it's likely that we're going to see an increase in Equal Pay Act claims as a result of the pay transparency rule, where someone finds out, wait a second, I'm making $18 an hour, and Sally, who was hired 4 years later than me, is making $19.10 an hour. And the only reason was because from an economic standpoint, Sally had more leveraging power at that period of time, so she was paid more. Additionally, the statute requires that if an employee comes to you and asks to get the range of pay for someone in their position, that you must provide that to them, which would give them then access. Anyone who has my job title is making between kind of this range of pay, however you define that range of pay, whether or not it's what's been budgeted, what the determined weight range could be, or people who are in that position right now. One way that I'm seeing people kind of get away or attempt not to do a full um, pay equity analysis while still limiting liability is by having a multitude of different job titles, changing job titles so that you're just like, for this random job title, this is the pay range. That's more difficult for more of our retail grocers where we're not going to have, you might have cashier one and cashier two, but you're not going to have like, produce stocker, you're not going to have it kind of that specific in things. So keeping in mind and starting to do the legwork now to prepare for that is really important, kind of more generally. And then one of the other questions I'm getting is, well, can I still put a help wanted sign in the window, or in that help wanted sign, do I have to do a range of pay posting? A posting in the statute is a solicitation to recruit applicants for a specific available position. It has to include the qualifications for the desired applicant. So if you just put help wanted in the window, you're not going to have to put the pay range on that help wanted. But if it was posted more generally as to who you're looking for, what the job duties are, then it would need to be included. And that's both if you put it in the newspaper, if you have it posted on the wall internally for internal candidates, or if you're posting it online on Indeed or LinkedIn or anything along those lines. So great question, Curtis.
I follow up a little bit on that because I think one of the signs I see most frequently, aside from like the generic help wanted in the majority of our members, is on the logistics side. I see a lot of drivers wanted type of signs, and even on like trucks passing on the highway. Is being generic enough as just drivers, or is it, or if you're asking for CDL drivers or something like that?
I think drivers wanted is broad enough that we don't have an issue and don't need to post it. However, if it said if we then added CDL qualified, X, Y, and Z years of experience, long haul, like those additional elements, that's when we're going to expect the pay range to be posted. But if it's just a sticker on the back of the 18-wheeler, I don't see that as needing to have the additional information about the pay range.
I know there are other New England states too with that law, and I think it's still up in the air if there will be rulemaking to clarify some of that ambiguity. I know Massachusetts has a good faith provision in their law that we don't have, so maybe some forthcoming clarity there.
It certainly would be helpful, especially in today's day and age, and for some of our more remote positions too. If you're looking someone in a certain territory and they can't live in Maine, if for our sales force or anything along those lines, understanding that interaction is also, important.
Well, seeing no more questions, I guess that will bring us to the end of today's webinar. A sincere thank you to everyone who joined us this morning and our partners. And Tawny, you are just amazing and a leading expert in the field of paid family medical leave. I appreciate you answering all of our questions, online, offline. You bring a lot of value to our industry. How should people get a hold of you if they've got more questions or want to follow up with something more specifically?
Absolutely. So the good news is that I'm really easy to find online. Only Tawny Alvarez in Maine. Type it in. You'll find my bio on Verrill, and it has all my contact information there. Don't hesitate to reach out. And I think we're going to share slides too. So you'll get a PDF of the slides, and my contact information is there. And Christine's been nice enough to share it more generally. So don't hesitate to reach out. I'm happy to help. Thank you all. Thank you, Nate and Christine and Curtis, for inviting me to do this.
Great. We'll be having an additional exchange webinars in the coming months, so please keep an eye out for those opportunities ahead. Thank you, everybody, for your time and attention this morning. Hope you have a great day.